This week on Just Solutions, attorney and author Maya van Rossum made a case for a new approach to environmental conservation in her 2017 book, The Green Amendment. In the newly released updated edition, Van Rossum once again argues that it's time for a new approach, environmental constitutionalism. She's the founder of Green Amendments for the Generations, which is a campaign to add environmental amendments to state and the US constitutions, and she empowers communities to claim their environmental rights. From Free Speech TV, Just Solutions. Maya, it's great to have you as our guest today. Thank you very much for being on Just Solutions.
Thank you so much for having me and helping me to have an opportunity to share this important message.
Well, let's dig right into this. What is a Green Amendment and why do we need it?
So a Green Amendment is an amendment that's added to the Bill of Rights section of our state constitutions, and ultimately we'll seek to get an amendment in the federal constitution that recognizes and protects the rights of all people to clean water and clean air, a stable climate, and healthy environments. And because of its constitutional placement and the language that's used, it literally raises up environmental rights. So they are given the same highest constitutional standing and protection as the other fundamental rights that we hold dear here in the United States of America, things like the right to free speech and freedom of religion. And we need this highest constitutional standing for our environmental rights because, quite frankly, our current system of environmental protection laws here in the U.S. is fundamentally failing us. We have people across the nation breathing contaminated air, drinking polluted water. We have ecosystems of all kinds that are being decimated and species being brought to the brink of extinction. And of course, present and future generations are facing a climate crisis. When this system of laws fails us, when it sacrifices communities, and particularly communities of color, indigenous communities and low-income communities, to pollution and environmental degradation in order to help business operations meet their business and profit goals, there's not really much that the people can do about it because it's very legal. It's all legalized under this system of laws. But if we were to have a constitutional right to a clean, safe, and healthy environment, when our government fails us, when this system of laws fails us, we, the people, could turn to our constitutional right to a clean, safe, and healthy environment to get transformational change and the needed environmental and human health protections essential for all of us to have happy and safe lives, including future generations.
Well, I'd like to talk a little bit more about how our current environmental regulations are failing us. And I've heard you say that they're actually enabling pollution. And you mentioned there environmental racism, the fact that communities of colour, particularly Indigenous communities, are bearing the brunt of this pollution in this country. So what is it about our current laws? You said there that they're actually on the side of the polluters. Dig into that a little bit more.
So many, if not most of these laws were passed decades ago. And really, the way I look at it, they were sort of a first step in helping us address environmental pollution and degradation, right? Back decades ago, we had people suffering from pollution and degradation, and we had political leaders and we had communities that recognized that actually a clean, safe, and healthy environment was good for all of us. Whether we cared about our healthy lives, whether we cared about our economy, whatever was our personal priority, protecting the environment was beneficial to everyone. And so we passed a series of laws that were designed to secure reviews and issue permits that would start to ratchet down pollution. And I think that was intended as a first step. The problem is we got this system of laws and they did start to lower pollution outputs and environmental desecration through this system of permitting. But then industry got a hold of the whole process and started to work with political leadership to make polluting and degrading the environment actually an entitlement of business and industry through this system of permitting, and overshadowed the right and needs of the people to a clean, safe, and healthy environment. And the process stagnated in this dangerous place. And actually, over time, we've reduced protections. We've created loopholes. There are gaps in the laws. New threats and harms are not being addressed by our current system of laws. And yes, the way this system operates, it actually, sometimes intentionally, sometimes unintentionally, truthfully, it doesn't really matter. It results in the consistent targeting of communities of color, indigenous communities, low-income communities for highly polluting industrial operations. So they are getting hit over and over and over again by one industrial operation after another, each issuing their own legalized level of pollution. And this pollution is literally stacking up and devastating their lives. So actually, communities of color, while 40% of the United States of America right now is breathing unhealthy air, communities of color are 3 times more likely to breathe the unhealthiest of the air as compared to their more affluent, whiter communities. And that's just one example. So environmental racism, unfortunately, is alive and well here in the United States of America, and isn't just allowed to happen under our current system of laws, but in many ways is actually encouraged. We keep foisting the pollution and degradation on these BIPOC and low-income communities so that whiter, more affluent communities can be spared the devastation of pollution and degradation.
Well, I'd like to talk about your pathway to this movement around the Green Amendment. Now, you've been involved in environmental activism for years and years, particularly in your role as a Delaware riverkeeper. But you write about it in your new book, your My Green Amendment Epiphany, and you take us back to 2008 in your home state of Pennsylvania and what was happening around fracking that led you to create this movement essentially around the Green Amendment. So take us back to 2008 in Pennsylvania. What happened?
So it was really around the mid 2000s, 2005, 2008, that range, when the fracking industry came to the Commonwealth of Pennsylvania and started to frack for gas from shale, bringing with it all of its highly polluting industrial operations, water contamination, air contamination, release of climate changing methane emissions, desecration of the natural ecosystems of the environment. And given the state of the law in Pennsylvania and nationally here in the United States of America, this system focused on legalizing pollution and degradation, it was really quite easy for the industry to overwhelm Pennsylvania's communities and Pennsylvania's environments. For me personally, I had been left a parcel of land, a lovely 68-acre forest by my mother, who unfortunately I had lost to pancreatic cancer. And she had entrusted to me this forest to protect for her grandchildren and, future generations. And the fracking industry, while it was not able to proliferate onto my property, because I would not allow that to happen, it started proliferating around and really harming our enjoyment of this beautiful forest that my mother had left to me. And around the same time, in the Delaware River watershed, we were finding that the fracking industry was trying to infiltrate into the boundaries of the Delaware River watershed, the Pennsylvania portion of the watershed. And we were learning at my Delaware Riverkeeper network about all the devastating consequences of fracking. And so really we're gearing up as an organization to stop this industry. And in fact, have done so with great effect. There actually is no fracking anywhere within the boundaries of the Delaware River watershed because of the work of the Delaware Riverkeeper network. But that did not spare my beautiful 68 acres left to me by my mother or other parts of Pennsylvania that were outside of the boundaries of the watershed. The industry was just having its way. But the way I describe it, for the industry, it wasn't easy enough for them to have their way with Pennsylvania's communities and environments in order to advance their devastating fracking operations. They wanted to find a way to make it even easier for themselves. And so very literally, they wrote for themselves a piece of legislation that was literally a gift basket to the industry. It was passed by the Pennsylvania legislature in 2012, signed by the governor, and came to be known as Act 13. This law, again, was a gift basket basket to the industry. It put in place automatic waivers from even minimal environmental protection standards. It alleviated the industry of the obligation to notify those on private drinking water wells that their drinking water had become potentially contaminated by nearby fracking operations and toxins. It preempted local zoning authority and mandated that fracking operations and operating drilling and fracking well pads be allowed, by virtue of this state law, be allowed to be placed in the heart of residential communities as close as 300 feet from people's homes. And so while fracking was already really bad in the Commonwealth of Pennsylvania, it was going to get exponentially worse if this law was allowed to go into effect. We at the Delaware Riverkeeper Network knew that we had to find a way to challenge it as one of the few organizations that engages in really strong activism, but also litigation. And so as we thought about our legal strategy for how to challenge this law, there weren't many options, right? Because it was passed by the legislature and signed by the governor. But we actually realized that in the Pennsylvania Constitution, there was this long ignored Bill of Rights amendment that recognized and protected the rights of all people of Pennsylvania to pure water, clean air, and a healthy environment. So we challenged that pro-fracking law as being a violation of this long ignored environmental rights amendment. And the case went all the way up to a very conservative Pennsylvania Supreme Court. And in December of 2013, we got this amazing victory declaring unconstitutional those devastating provisions of Act 13, stopping the law from starting before it ever happened, right? Before it could ever be implemented. And at the same time, breathing legal life into this long ignored environmental rights amendment, what I now call a Green Amendment. And I thought about, wow, how powerful. We couldn't have had that victory without the Constitution. So I looked at every state constitution across our nation and found that at that time, only one other state had this kind of constitutional, most powerful constitutional provision, Montana. And I decided I was going to change that and get it in every state across our nation and at the federal level. And so I started my Green Amendment movement.
So how many states right now have you been working with, are working with, have maybe changed their state constitution? And what will be the tipping point to start then the efforts to have this in a federal constitutional amendment?
So we are working in with communities in over a dozen states at this point, and they're all at varying degrees. Some are at the beginning stages. Some, like New Mexico and Maine, our actions and our activities are much further along and are very robust. But there's so much interest because of the empowerment, both in terms of the grassroots, in terms of grassroots advocacy and activism, but also the strength that we get when we legally accomplish a constitutional Green Amendment, that there's just amazing and growing interest. And I'm getting outreach from communities in other states all the time. But it is a relatively new movement, right? So, and it does take a little bit of time to pass a constitutional amendment. Constitutional amendments are very accessible at the state level, which is one of the reasons why we're starting at this state level, but it does take a little bit of time. But that being said, not only are we working with communities in over a dozen states at this point, from coast to coast and in the state of Hawaii, but we actually secured passage of a constitutional Green Amendment in the state of New York in November of 2021 with over 70% of the vote of the people.
Well, we would love to hear from our viewers. Let us know your thoughts on this. Maybe you're in one of the states that Maya Van Rossum is working around this issue of passing a Green Amendment. Drop us a comment, let us know your thoughts, and join the conversation. Maya, there's another movement that reminds me a lot of what you're doing, albeit it is a little bit different, but I'd love to hear your thoughts on the intersection. What about the rights of nature movement, which actually fundamentally tries to assert the rights of nature itself to have legal rights? How does that intersect with what you're doing?
So I want to say, I personally very, very much believe in the rights of nature. I think it's powerful and it's important, and I honor nature and its own right to be here on this earth with we the people. But fundamentally at its core, what the rights of nature movement is about giving nature the ability to sort of go into the courtroom with its own lawyer and advocate for itself and enforce environmental protection laws that are being violated and resulting in harm to nature. And so the while I value that very, very much, and it's very powerful and important intellectually and can be powerful legally in terms of helping to enforce the laws on the books, the problem is when the laws on the books aren't effective enough to protect nature or people, then whether it's a person enforcing the violation of those laws or nature itself, we're sort of at the same place. We are enforcing a series of laws that allows increasing pollution, degradation, and desecration that is causing harm to nature, species, and to people. What the constitutional Green Amendment approach does, right, is it creates this constitutional right that is above the laws, so that when enforcement of the laws we have on the books does not provide the necessary level of protection for nature or people, when there are gaps in the laws or loopholes that allow industry to get away with inflicting their damage without government oversight, or when we have the perpetuation and growing problem of environmental racism, we the people can turn to the Constitution, because the Constitution is above the law. These laws are supposed to serve that constitutional right. And if the laws aren't conserving the right because they're too weak or there's a gap, we the people can turn to the Constitution and say, we have a constitutional right to a stable climate, to clean water and clean air, healthy ecosystems, healthy species populations. Those rights are being constitutionally violated, and we can seek to enforce the constitutional right in its own right. And so what the Green Amendment do will help raise up the level of environmental protection we get for people and for nature. And so as the rights of nature movement itself progresses, providing legal standing for nature, nature will be able to advance and, an enhanced level of laws. But they're different approaches. One is allowing nature to enforce the laws on the books, and the other is really raising up the environmental rights and environmental protection to this higher and highest constitutional standing.
Well, I'd like to talk about the need to have that, to almost have the rights of nature so codified in state constitution and then ultimately a federal constitution that it is above the laws. Because if you look at some of the decisions coming out of the current Supreme Court around environmental regulation, in many ways they're undermining the authority of our current environmental regulators. I'm thinking back to West Virginia versus the EPA, and the indications that the current makeup of the Supreme Court will further go down this route of diminishing our current environmental regulations, which, as we're hearing, and many people really feel that are already inadequate. So talk a little bit more about that it seems now, because of what's happening at a Supreme Court level, it's even more urgent to have this explicit language stated around environmental rights.
You are so right to be raising up the recent Supreme Court decisions, both those that are environmentally focused, but those that are focused on the bodily autonomy of people, as well as recent decisions focused on the provision about the right to bear arms. What this recent set of U.S. Supreme Court decisions has done in the first instance is it has really just highlighted for a whole new audience of people the power and importance of this Green Amendment pathway, securing explicit recognition and protection of the environmental rights of all people at the state and federal level, so that all people can see, recognize, and understand the power of explicit rights protection, whether you're talking about environmental rights, bodily autonomy, etc. But the truth is that we have been seeing cases of this kind happening at the state level for years, where people are seeking to enforce constitutional provisions in state constitutions that don't meet my Green Amendment criteria or definition, and where the court has chosen to, and sometimes based on the language of the provision that is not explicit and clear about environmental rights, has in some ways been forced to, based on the plain language of the amendment, to say, no, the right to a clean, safe, and healthy environment is not given the same constitutional standing as other rights. As much as we want justices to read that into the language doesn't say that. So we can't do that. And so when we look at those federal decisions, right, we actually see a different version of the same thing. In the Dobbs case, where the right to an abortion was rolled back, the reason why the U.S. Supreme Court was able to render that decision in no small part was because the right to an abortion was read into language that didn't explicitly state it, but implicitly stated it. But the court was able to say, look, the right to an abortion is not explicitly there. Therefore, we can go down this alternative path and we can take that right from the people of the United States, from women and others who happen to have a uterus. In the case of the right to bear arms, we see the Supreme Court all the time saying, look, the right to bear arms is explicitly in the Constitution, and therefore we are going to undermine common sense gun protections, right, gun regulations in ways that have devastating consequences for the health and safety of our children and our families and our communities. But the Supreme Court can get away with doing that because it says there's explicit language protecting the right to bear arms. But there is no explicit language, right, to a clean, safe, and healthy environment. So in the environmental context, like in the case of bodily autonomy, when we try to get the court to read environmental rights into the right to property or other language that's in the federal constitution or in state constitutions, the courts can get away with not finding that protection. And again, sometimes they're just forced into that corner because the plain language of the constitutional provision, whether state or federal, just doesn't give that environmental right. But a green amendment ensures, when I work with communities, we make sure that we are advancing constitutional language, again, in that Bill of Rights placement that is so critically important and fulfills other fundamental criteria that ensures the right to a clean, safe, and healthy environment, including a stable environment, is clear and is explicit. So even if justices want to ignore or undermine that right, they are hard pressed to do so. So that's why it makes a difference. And I realize I didn't answer your question about, when will we be at the right moment to get a federal green amendment? And I just want to acknowledge that really important question. The reason why we're going state by state first is, first off, in the environmental context in the U.S., states have a lot of power when it comes to environmental protection. And so too does the federal government, right? Both levels of government have that power. So at both levels, government officials need to be held accountable under the Constitution for protecting environmental rights. So we need green amendments in every state constitution to hold state government officials accountable and local government officials accountable, right? Local town councils. But we also need to be able to hold our Congress, our president, and our federal regulatory agencies accountable. That's why we need green amendments at both levels. At the state level, constitutional amendments happen all the time, and they very much are driven by what the people of the state want, holding their state government officials, their state legislators accountable to pass a constitutional amendment of one kind or another. So at the state level, because of this process that happens and the relationship between the people and their state legislators, getting a state constitutional amendment is much more doable in the near term. And when we get state green amendments, we get the same kind of powerful protection I exemplified for you in the earlier example in Pennsylvania. And we are also at the same time educating people about how the law works, how it's fundamentally failing us, how constitutional green amendments can change that. And so going state by state by state, we are not only getting this powerful protection at the state level, but we are building the foundation of awareness and support necessary to ensure that when the time is right, and I think we're just going to organically know when the time is right to pursue a federal green amendment, we will have created the foundation necessary to get the support of 3/4 of the states necessary to pass a federal green amendment. But that's what it takes. But if we hop to the federal level too soon, we're going to suck all the, oxygen out of the room, and all the money's going to go towards this federal green amendment that we haven't appropriately laid the grassroots foundation for. So we're better to go state by state, get this powerful protection, create the foundation of understanding, awareness, and support so that when we get to that right moment, we will be ready to pursue and secure the federal green amendment.
Well, Maya, we just have a few minutes left, and I do want to ask you about how your movement is really empowering communities and individuals and really at a local level. Because right now we're seeing an increase in what's being dubbed climate anxiety, where people are feeling this sense of powerlessness and hopelessness when it comes to this such a huge existential issue. So how does your movement actually empower people by reframing their ability to see themselves as really part of the solution?
That is one of the things that really is so powerful about the Green Amendment movement. As you said, people see themselves as the movers, as the doers, as the ones that are making this happen. Because fundamentally, every constitution is a document of the people. It's we, the people, saying to our government officials, we're giving you permission to govern over us. But in the granting of that permission, we're making clear that there are aspects of our lives, of our world, that you may not infringe upon. Right now, that includes civil rights and free speech and the freedom of religion and other fundamental rights, but it doesn't include the environment. So now we're adding the environment. And it's we, the people, saying to our government officials, when you govern, you may not infringe on our environmental rights. Because the constitutional amendment process at the state level at its core is dependent upon the understanding and support of the people. It is driven by the people. And so it is very, very empowering. It also helps people change the way they think about and talk about the environment and environmental protection. Right now, when they go to public meetings and their government officials rule against them, too often they're forced to sit down and shut up because very literally the law said that the environmental sacrifice that just happened is legal. And there aren't really many options for the people. But when people understand that they have an inalienable right to a clean, safe, and healthy environment that's being ignored by their government officials, they get a sense of entitlement that gives them a strength of language and presence and demanding that really changes the framing of the conversation for them and their interactions with their government officials. And that sense of entitlement is strengthened by the power of knowing that actually at its core, we the people can change the structure of the laws that is allowing that to happen by seeking and securing and advocating for the passage of constitutional green amendments. So it really does change the way we emotionally, intellectually, and legally think about, speak about, and are entitled to environmental rights protection.
So I know that you are working with different communities. You mentioned there about a dozen communities right now, or a dozen states. So it sounds like engaging with your organization is a definite path forward for folks who might be interested in pursuing a green amendment in their state constitution, because there's a lot of legal layers to this. So talk a little bit in the last moment that we have, Maya, how people can best engage with this process and connect with you.
So the Green Amendment message is really simple, right? We're all entitled to a right to clean water, clean air, a stable climate, and healthy environments. But as you suggested, it can be kind of complicated and complex to get it right. So what I ask people to do is please partner up with me. Let me help you be the leader in your state to make this constitutional Green Amendment movement happen and help you get it passed by empowering you and educating you and standing with you as a partner while you help and lead this movement. In every state where we have a Green Amendment proposal advancing, it started for a different reason. Sometimes it was an organization, sometimes it was a legislator, but very, very often it was one person who heard a show like this and picked up the phone and very literally called me. And we got to work together to advance the Green Amendment strategy in their state.
Well, Maya, it's been great to have you with us. Thank you so much for being our guest and joining us to talk about your new book, The Green Amendment, and the entire movement you've created around the Green Amendment. Thank you so much.
Thank you for having me.
And we would invite you to participate in the conversation. Drop us a message on social media and let us know your thoughts on this issue. And don't forget to subscribe to the podcast of Just Solutions so you never miss an episode. And join us same time, same place next week for another conversation from Free Speech TV's Just Solutions.